Hi, it's Adam Goldstein at the Student Press Law Center. Like a lot of people, I saw the story in the Washington Post about the Prince George's County School Board considering taking a policy that would purport to grant it the right to ownership of some student work. And I had some additional thoughts I wanted to inject into the conversation. If you work for PG County, you might want to get a pen. I'll wait. While you're getting it, I guess for the rest of us, I'll point out that I knew there was like a cognitive issue here when the district spokesperson said, if nothing else, the district has common law copyright over teacher work. And I thought, like, well, there's a slight obstacle to that, which is that, common law copyright hasn't existed in the U.S. since 1834. I mean, it hasn't existed since there was a federal copyright, but the Supreme Court recognized there was no common law copyright in 1834, Wheaton versus Peters. So first step to getting a common law copyright, hop in your DeLorean, crank it to 88, and go back to 1834. So, yeah, I thought maybe I could flatten the learning curve and fill in some of the blanks for them. So, hey, I hope you're back. I hope you have your pen. Great, let's start writing something down. Let's write down Title 17, Section 201A. Title 17, Section 201A of United States Code is what defines who owns a work, and it says that except in the cases of a work for hire, ownership vests in the author or authors, which obviously would be the students. So what's a work for hire? Title 17, Section 101, the definition section, lists two cases where this might not be true. One, a traditional employment relationship, and two, when there's a signed writing, signed by both parties, that specifies the intent to create a work for hire. So let's go through those two explanations. Which of these things do you think a student fits into? Are they employees? Well, the Supreme Court, in the Reid case, analyzed what it means to be an employee, and they listed 12 non-exclusive factors of agency to measure someone's status as an employee or not as an employee. Among those factors are whether the hiring party is in business. I'm going to say you're probably not, because on account of you're the government and you're a nonprofit, so you're not supposed to be in business. Two, the provision of employee benefits. So I don't know what kind of dental you give your students, but that would certainly help your case. The tax treatment of the hired party. Have you been properly withholding Social Security income for your students, employees? So we could go through this in more depth, but the Supreme Court actually did summarize later on in the case. And they said that in using the word employment relationship, Congress meant to refer to, quote, a hired party in a traditional employment relationship. That's 790 U.S. at 743 in the Reid case. So I'm going to go out on a limb and say your students aren't in a traditional employment relationship. One way to tell is that if you quit your job, they don't send a truancy officer to bring you back to it. Whereas if you just decide not to go to school, consequences ensue. So, okay, well, what about a signed writing signed by the party against whom enforcement is sought? You just have all the students agree to give you this stuff. Well, there's a couple problems with that. Like, let me put it this way. I'm guessing the state of Maryland has like a free and reduced price lunch program, and I'm guessing PG County offers some of those lunches. Let's say a student's on his way to the lunchroom, and somebody stops him and says, before you're allowed to have your lunch that the state of Maryland paid for, you have to give me half. Or better yet, you have to give me all of it. Well, what would you call that? I would think bullying is a fair description of that behavior. Would you go with bullying? Okay, so what you want to do then, is to say, before we give you access to the technology that the citizens of Maryland have already paid for your benefit, give us the result. If that doesn't violate like the standards of bullying, then you need to rewrite bullying, because that's the definition of bullying. Before I'm giving you something to which you're entitled, give me something. I mean, that's like mob protection money. I don't think your biggest problem is copyright law. If you do that, it's racketeering charges. So, even if you did that, even if you got students to sign that, you have a further hurdle, which is that, remember, minors can void contracts till they're 18 if they're for non-essentials. So even if I, as a student, like I'm a 15-year-old in PG County, even if I sign that agreement, and for some reason I don't call the media, and I don't tell my parents, and you don't get sued, I create the stuff and then I wait 2 years and then I void it. And so I'm 17. I want my stuff back. I mean, the kicker to all that is that you're not even entitled to have a policy that deviates from federal law. You're a government agency, yes? You're the government. Copyright law, federal copyright law preempts state copyright schemes. You're not entitled to have a system that is different than the federal system. You can have, like clear definitions that fit within the federal system, and you can have definitions of what is within the scope of employment for your employees. But there is nothing you can write that is going to make it okay to hijack student work from students. And the one thing that I do feel pity for you about is that this isn't the first time I've heard this. I have emails going back from 2007 of other schools proposing some kind of creative system where they would own the work. And it's failed there too, because they're not entitled to an opinion. It's what federal copyright law says is what the law is. And that's the only pity I have here, is that you're getting credit for creativity that isn't that even that creative. So if you have further questions, if you have further confusion, you can contact the Student Press Law Center. 703-807-1904. I'm extension 122 because I'm sure you want to talk to me. You can email me at agoldstein@splc.org. That's AGOLDSTEIN. And if you're a student in PG County and you need help, well, contact me too. I'll be glad to do it. So I hope this clears up the confusion. Good luck.